Okay, that's starting. Hi everyone, hopefully we are now live. Welcome to Trinity Talks, the second in our series. I'm Simon Norris, one of the partners at Trinity International. And today my colleagues Fiona Gulliford here in London, Eric Philippink and Augusto Repetto are going to be talking to you about closings during COVID-19, giving you some of the practical tips that we've learned from closings over the last few months. In terms of format, it's 30 minutes of talking from the three of them and then some Q&A. And you can ask those questions at any time on the chat function, which you should be able to see on your screen. So without further ado, I will try to hand over to Eric. Please excuse a middle-aged man trying to use technology. Eric, over to you.
Thank you very much, Simon, and thank you everyone for joining us today. So we came to this topic to discuss closing issues with you after several recent closings that we are involved in both our London and DC offices, where events forced us to find alternative solutions during the COVID lockdown period. Effectively, we were finding workaround solutions in real time as we confronted cascading closures in the United States and in Europe, as well as in the local jurisdictions in Africa and Latin America, where the transactions were being completed. So we thought that it would be a good idea to present what we have learned to you, as Simon said, not only because they applied during the COVID pandemic, but also because these are issues of a general nature, and they are important to consider for any type of closing. Now, experience shows us, and I think you as our clients also know from your experience, that parties and their attorneys often leave these closing mechanics to the last minute. So even as CP documents may be in the process of being prepared and you're on track for doing that, the actual closing logistics themselves can trip you up without sufficient planning and if you do not provide sufficient forethought. So now, while lockdown may have eased in Europe and the United States, infection rates are still increasing in parts of Africa and Latin America. So we cannot dismiss the possibility that there, or even in places that have reopened, that new waves of infection won't mean that we won't be facing new lockdowns of a cascading nature around the world as we try to close our transactions. So contingency planning needs to really be part of the closing strategy, and we can't stress enough that you need to discuss this as early as possible. So what do we mean by closing logistics? We are referring to actually very seemingly simple things that, as we have found, lead to an inordinate amount of time for discussion and planning. We are talking about things like your signatories, identifying your signatories early, not just who the parties are, but meaning the actual persons who will be signing, and confirming how they will sign to make sure ahead of time that they have the necessary equipment. If you're in a lockdown situation, your signatory is sitting at home. Do they have a printer? Do they have a scanner to scan their signature? If not, they may have to sign electronically. But as we will be pointing out throughout the course of today, most of our transactions involve securing collateral in local jurisdictions or having other types of documents that need to be registered in a local jurisdiction. And more often than not, original signature pages, meaning wet ink originals, are almost always required. Therefore, you need to consider these practicalities. Something that may seem very insignificant, such as the size of the paper. If you have signatories in the United States and in Europe or elsewhere, you will have different sizes of paper. So if you're going to be registering documents in a local jurisdiction and you have signature pages that you need to collate together, some being US letter size and some being European A4 size, you're going to have mismatched papers. These can easily be rejected by registration authorities, as we have found. Therefore, you need to plan for getting A4 paper to signatories in the United States, for example. This can be ordered online or as we have found, you may need to ship pre-printed signature pages to the signatories. So all of this planning means you need to factor in delays. So delays in identifying your signatories. If the intended signatory is not available, you may need a power of attorney, which often will require original signature pages, as well as powers of attorney will almost always need to have original signature pages. You may need to have corporate resolutions or board decisions appointing other authorized signatories if your intended signatory is not available. Think about witnesses and notaries. If you need a witness, are the witnesses available? And will they actually be able to witness the signature of the document? Notaries, signatures that may need to be notarized in jurisdictions. Through our experience, we have found that registration authorities can be quite strict. We've had the experience where a document was notarized and had attachments that were notarized by a different notary and were rejected because the notaries were not exactly the same, and we had to have the document re-signed from the start. So you want to avoid something like that. And when you are doing the planning then, and you may need to have new pages signed, think about courier delays. We have had documents trapped at airports. We have had them locked up at FedEx and DHL offices because the documents meant that nobody could leave their home to go fetch the documents. And so this led to additional, sometimes weeks of delay in terms of compiling the documents and submitting them for registration. Once you get to the registration stage, you need to factor in time and delays for any contingencies there, for documents being rejected, for signatures that need to be re-signed, time for obtaining proof of registration, particularly if lockdown means delays in staff of the registry services being available. We will discuss more of that later on in this presentation. So taken together, this can easily amount to a 2-month period just for the signing and filing registration process alone. So you need to count backwards. So if the borrower needs a disbursement by a certain date, count backwards and consider the length of time it's going to need for all of these contingencies and potential delays. The point is to manage expectations. With good planning, you can overcome these, but you may still be surprised. And now at this point, I'm going to turn over to my colleague Fiona, who is going to discuss signature pages.
Great, thanks, Eric. Good afternoon, everyone. So you've identified who's going to sign your documents, but then you've got to still make sure that you get your signature pages correctly completed and that people actually sign them properly. So one point that Eric made, which is getting the format correct. And I think, again, this also goes back to, are you all printing on the same paper? Where you may have North Americans and Europeans signing, it may be that the printing paper available to them is of different sizes. The second point is not to rely on precedent signature pages. Certainly, under English law, we would never really want to do that. And you've got to bear in mind, what is this document that is being signed? If it's a simple agreement, then probably you will have a very simple signature block. If it's being executed as a deed, as we'll come on to discuss in a moment, the signature block may be slightly different and the requirements for signing are different. So obviously you can't just simply replicate the same signature page for each document. And as I said, the signature blocks of parties therefore may differ depending on what they're signing and what your corporate authorizations say you need to do if you're signing a simple agreement or if you're signing a deed. I'm aware that for non-English companies, deeds are not necessarily an issue. And you may just simply have one set of rules governing how you are able to validly enter into agreements. But for English companies and companies who are based in jurisdictions based on a common law set of principles, it is not unusual that they will also have special requirements for signing as a deed. So these should be checked. when we are signing deeds under English law, you do require a number of parties to sign these. So ordinarily, you would probably have 2 directors. You could have a director and a secretary, or you could simply have your signatory with their signature actually being witnessed by another party. Now, obviously, when we're in a lockdown scenario, getting someone to be able to zip round and actually witness a signature is really quite tricky. So a number of questions that we were asked where we had deeds that did need to be witnessed is, well, if I sign this document in front of someone and I've got the Zoom screen on, can they simply watch me signing on Zoom and that's sufficient for them to say that they've witnessed my signature? And I think, unfortunately, the answer to that question is no. You would really need to have your your signatory physically in the room with you when you are signing. Now, there are several ways around this because, again, with lockdown scenarios, there is an obvious difficulty in having someone physically in your home, particularly if you live alone, able to witness your signature. So I think what we would urge parties to do, and this goes back to Eric's point of thinking and planning in advance, is thinking whether you really need a witness and whether you can actually have 2 directors or a director and a secretary, and then they can both sign remotely without the need for a witness. A question that also comes up is, well, obviously my colleague that would have witnessed this isn't living with me, but I've got members of my family at home. Can they witness my signature? And I think we would say, except in absolutely extreme circumstances where there is no way around, you don't have another director, there is no way around the witness requirements, we would not really encourage this, because if you have a member of your family sign as a witness, if your document is ever needed to be used in evidence, there is a thought that really, if you've got a family member as your witness, it could cast doubt on the reliability of them as a witness. The next really important point is obviously always consult with local council. There may be additional requirements. We had some difficulties in some jurisdictions where they said if companies had seals, then some of our documents had to append company seals. So again, it's not as simple as just assuming, well, we can do this for our documents, so it should be fine for other documents in other jurisdictions. We're going to come on in a moment to talk about actually what I mean by e-signing, what an e-signature is, and all the process for doing that. But I just want to emphasize that we're talking about deeds and witnesses and how documents need to be signed under English law. But obviously the practice is very different under New York law. And I know for some of the audience, you may be more familiar with pre-signing your signature pages, things that we don't do under English law. So I'm going to hand over to my colleague Augusto to describe New York practices for you.
Thank you, Fiona. So there is an understanding among New York-based lawyers that cross-border transactions require flexibility on all parties when it comes to a closing. So what you will generally see in New York law documents and in a New York law type closing is that scanned or faxed signature pages are valid and enforceable, and that originals are collected and distributed shortly after the closing. Scanned signatures as opposed to faxed are preferable, especially if they're forwarded by the attorneys for the executing parties. Now, you are also going to see that the agreements provide for the validity of counterpart signatures. It means that the signatures do not have to be all in the same signature page, which in turn means that the signature can be in 2 different places. And that signature pages are usually delivered to law firms in escrow, which means that they can be released only upon the instructions of the signing party or the attorneys for the signing party. Finally, what you will also see is that documents do not have page numbers in the signature pages. usually what you see is a footnote that says signature page for such and such document. And this is designed to make life easier if there are subsequent changes in the documents, and that might alter the number of pages in a document. So with that, I'll turn it over back to Fiona.
Thanks, Augusto. So moving on then, virtual signings versus e-signings. I appreciate that using this language, it may sound a bit confusing. How do you distinguish a virtual signing from an e-signing? Well, more often than not, it's not really practical for parties to all be in the same place. So what we're all probably very familiar with is virtual signings, where signatories will sign a hard copy of a document in wet ink. They will scan that signature page and if necessary, the copy of that document back to all the parties, and that will constitute the copy for the purpose of signing. But the original document will still be an original wet ink copy that will be collected after the fact. So you'll find with most project financings, for example, you can reach financial close by providing, or you can reach signing by having signed that document with originals to follow for the purpose of financial close. When we talk about an e-signing, we mean that actually what parties will do is slightly different, because in a virtual signing, you print off a document, you sign it, you scan it, you send it back, and you have an original wet ink copy. For an e-signing, the document that you e-sign will essentially be the original copy, because you are not providing a written wet ink signature. So e-signing is very different because that one document is your original document that you are then signing electronically. The next thing to consider is, okay, fine, that's going to make my life easier if I don't have to print something out. But how do I e-sign? What constitutes an electronic signature? And I think there are several ways in which you can attach your electronic signature to a document. The first is by simply copying and pasting a copy of your handwritten signature into the document signing block. The second, which is probably quite common for people working on tablets, is to use a stylus pen, or if the technology allows, just using your finger to sign your signature on the document that's been circulated. And thirdly, we are aware there are a lot of third-party software out there, websites where you upload a document and they sort of produce an authenticated signature for all parties. I think if we're trying to manage a big project financing, the preference, particularly amongst lawyers, would certainly be to go for one of the first two options rather than a third-party software. This is simply because when you're managing a lot of documents, it is much easier to be able to be in control and send those documents around and ensure that they are signed in a proper order. For example, if you have direct agreements, you certainly don't want to sign the direct agreement before the underlying agreement that it relates to has actually been signed. It also makes it easier for us as lawyers to have control of when that document is dated. And for various reasons, we may need to hang on to the document and then date it once we've obviously received all the signature pages. But it just makes it a little bit easier to control. And under English law, there is no problem with e-signing a simple agreement. You can, in fact, also e-sign deeds. There are a few other things to be aware of, as we've discussed, things like witness signatures with deeds, and also in terms of the actual delivery of that document. And I think it's also worth very quickly emphasising that under a normal English law signing, you would receive an email attaching the documents, and also you would be required to send back a confirmation with all the usual confirmations with respect to having read and agreed the document, being authorised to sign the document, agreeing it'll be effective once we've received all signature pages, for example. that Mercury signing instructions would still apply for an electronically signed document. So it is very important to ensure that the signatory who is signed electronically does still complete that authorization, and that they send back that authorization together with the signed document from their email account. I think when we're dealing with e-signatures, obviously because we're not seeing a scanned copy necessarily of someone's signature block, we do need to see that it is at least coming from their email address. And I know that when we do virtual signings, for example, it is not uncommon for assistants to send documents on behalf of the party that is signing. But I think we would urge caution when e-signing that the signatory does this themselves. Now, all of this assumes that we are able to actually provide e-signed documents. And as we've said before, for simple agreements, it's probably fine. For deeds, you can in fact do it. But you've got to really have a think about what the document is that you're signing, and does it need to be delivered anywhere else? As Eric touched on earlier, if you are signing an original security document, it is quite unlikely in the jurisdictions where we work, particularly in sub-Saharan Africa, that a registry that may require that document would accept an e-signed document. So actually, you would probably have to go back to a virtual signing and have wet ink signatures so that originals could be provided to the registry. And I think it's also worth bearing in mind that it's not simply security documents. Often loan agreements need to be registered with a central bank. And again, that may mean that your loan agreement will need to still have wet ink signatures, because again, central banks are very unlikely to accept e-signed documents. So, and very quickly, another important point to bear in mind is, are you authorized to sign documents electronically? So I would urge, as part of the planning process, any party to check their corporate authorizations and ensure that actually e-signing is a valid way of signing for their organization. And if you're in doubt, or if it's not, I would suggest that you make amendments to allow this to happen. And then finally, obviously there may be parties who are still able during a lockdown scenario to scan, sign and do a wet ink copy. And some financial institutions in particular may prefer to have wet ink original copies. So can parties sign in mixed formats? Because some parties may say, well, for the purpose of actually getting the document to you during lockdown, I can't get you a wet ink, but I can get you the electronic signature. So can parties sign a document virtually and electronically? And the answer to that is yes. You can have a mix of signatories for your document, but it does very much depend on the parties involved in the transaction, because again, the parties may have their own preference internally, so you need to check that they would be comfortable with that. In New York, there is the New York Electronic Signatures and Records Act, and Eric will describe this to you.
Thank you very much, Fiona. Yes, under New York law, we have since the year 2000, the Electronic Signatures and Records Act, which is also mirrored in federal legislation under the e-Sign Act. And documents that are signed electronically in the ways that Fiona described in e-signing are also legally valid in New York State. Now, there are a few types of documents that still need to be signed in originals, and these are documents that we normally do not deal with, such as wills, for example, or other estate documents. But for cross-border transactions, documents under New York law are able to be signed electronically. And usually good practice will have a provision in the agreement that also allows for this, although it's not absolutely necessary since it is legal under New York law, under the ESRA. Now, the point that Fiona made, again, about whether or not you can sign electronically is really going to be determined by what you are doing in your local jurisdiction. So as I now move on to discussing security documents, this needs to be borne in mind because the security documents will need to be filed with local registries, and these will almost in every case require to have original wet ink signature pages, irrespective of the fact as to whether under English law or your agreement is under New York law, that the e-signed document may be legally valid. And one of the options that Fiona discussed is using third-party software. And some of you may be familiar with DocuSign or Adobe that allows you to either sign with a sort of font that is added to the signature or a registration number that comes up that proves that you have electronically signed. That will be impossible to be registered in a local jurisdiction if you are trying to file your security document. And we've even had experience. So let's take a step back and say, what are we talking about when we are saying the registration of security documents? So we need to plan time for all of these steps. Essentially, there are 3 steps. First, you will have your document that on which the borrower will need to pay stamp duties. And then it will be stamped and then sent on for the registration process at the registry. And the registries in sub-Saharan Africa, and where we conduct many of our transactions, are in various stages of moving to electronic platforms where documents can be uploaded. But we are finding that even in places where they have electronic registries, that the original documents are still required as part of the process, including at the stamp duty stage. So for example, in Nigeria, which has moved to an online platform for its Corporate Affairs Commission and the National Collateral Registry, the stamp duty process, we were told, required to have the original signature pages, even if after that you could upload the documents electronically. So as we go through the different steps, you may find that some of the registries or some of the procedures are out of step with others in terms of what their requirements are. And so again, it's always advisable to talk to local counsel to know this. Generally in Anglophone Africa, you will have some form of a company's registry where you would register your debentures, and share pledges would be also registered in some version of that or an offshoot of a collateral registry, sometimes under the same umbrella, sometimes as 2 different distinct offices. Each jurisdiction is some version of the same theme, but generally we will find first stamp duty payment and then the registration with a corporate or company's registry, a collateral registry, and then you will need time for obtaining back the registration to prove that the registration has actually taken place, and that will demonstrate that you have a fully perfected security interest. And one thing to bear in mind is that there are different deadlines. So from the date of a document, you have in some cases 30 days to register that security document with a local registry. Sometimes in the case of Uganda, you have 42 days. Some cases in Nigeria, for example, you have 90 days to register your document. So you need to plan accordingly. And what we found is that it is good practice, almost essential, that you not date your documents until the very last minute when you have all of your original signed pages in hand. Because as we have found, if there is a mistake in any of the signature pages and you need to re-sign any of those pages, you need to send back through the couriers to get the new signature pages to be added. And if you've dated your document, the clock starts running, and then you may risk that you will not make it in time for the filing deadline, which will then necessitate you having to appeal to the court in order to obtain the permission for a late filing, which will require affidavits, which again will require original signature pages in order to fill all of those requirements. So I mentioned that many registries in sub-Saharan Africa are moving to electronic format. We are finding that even some of the advice that we had received from these registries even 6 weeks ago is now somewhat out of date. For example, in the case of Uganda, we have been told that some of the filing procedures that we had been advised are no longer necessary because they are encouraging the use of their electronic format under the SIMPA, the Security Interest Movable Property Act platform. But also in countries like Tanzania, where the BRELA, the Business Registrations and Licensing Agency, also has electronic filings that can be done online. We are finding there that staff may not be properly trained and that you have to intervene directly with registry officials in order to discuss your particular situation, in order to obtain the registrations and complete the procedures as necessary. Kenya, we have found that where we have appealed for, let's say, leniency in terms of the requirement for original signature pages because of COVID, these appeals have been rejected, and we are waiting for the registration offices to reopen. Some services have been restored as of last week, so some documents can be filed online, but others still must be held back and filed in person and in original form. We've also found that, I think as Fiona mentioned about seals, some documents may require seals. If you're filing some documents with central banks, for example, loan documents, may need to have the seals of the borrower and the lenders added to them, which you may not have planned for, and you may be surprised that your documents are rejected. Likewise, authentication of signatures may require apostilling, and we've seen in lockdown that consular offices and local government offices that would authenticate signatures have been closed. So here again, these add to those delays. This is why planning is so important and why expectations need to be adjusted accordingly. I'm now going to turn back over to Augusto, who is going to talk to us about notary issues and the particularities of promissory notes in your closing.
Thank you, Eric. So these are two of my favorite subjects and two subjects that I spend a lot of time dealing with when I'm dealing with a closing. The notaries, or escribanos públicos or notarios públicos, are a typical feature of transactions in Latin America, especially secure transactions. They not only certify the validity of signatures, but they also issue documents such as mortgages that are eventually registered in the property registry to perfect a security interest. They also check that property, especially real estate, can be properly mortgaged. So they act in a way that is akin to title insurance companies in the US. We have one COVID-related issue and one non-COVID-related issue that I wanted to comment on. Working on a transaction in Ecuador, and in Ecuador and in other countries of Latin America, during the COVID and the pandemic and the lockdown periods, escribanos have been prevented from acting altogether. They can't do any work. So what we have done is and expecting that there might be a second wave of closings eventually, is to have all documents ready to go and prepared so that as soon as the restrictions are lifted, the notaries can sign and certify all the documents and file them with the appropriate registries. That's a COVID-related issue. A non-COVID-related issue that folks need to be aware when dealing with escribanos públicos in Latin America is that in many countries, escribanos públicos are organized through a bar that has lobbied heavily to have fees based on the amounts of the transactions, which in a large transaction can be prohibitive. Of course, in many jurisdictions, parties can negotiate down those fees from the escribanos, and I strongly urge folks to focus on this early on rather than leave it until the last minute. And now to my absolute favorite topic for closings is promissory notes. So I used to work for 2 financial institutions a few years ago, and I used to tell my clients that all documents in a closing are important. Every document, the loan agreement, the disbursement request, the certifications that the reps and warranties are true and correct. You need to make sure you have all of that. But if there is one single document you want to make sure that you have and it's bulletproof, it's the note. And you'd be surprised at how many very sophisticated investment officers had to be made aware periodically that you need an original promissory note. No matter how you arrange the closing, you need to make sure that at the end of the day, you or your lawyers have the original promissory note signed by the appropriate party, if possible, with that signature certified by a notary or by a escribano público, if that is occurring in Latin America, and that your lawyers certify in their legal opinion that that is a legal, valid, binding, and enforceable promissory note, because that is the first document that you're going to be looking for if the deal goes south as a lender. And regarding promissory notes, there's been a couple of developments over the last few years that I've noticed that I think are worth mentioning in this presentation. One is that the promissory notes, there seems to be some restrictions in moving promissory notes from one jurisdiction to the other because of custom laws that prevent the delivery or the transport of negotiable instruments. So if you're going to have a deal in, for example, somewhere in Latin America, but then you're going to require that a note be moved to the US, you need to plan in advance, and you need to figure out how you're going to get it to the US in a way that is legal, of course. And if you're going to keep it in the jurisdiction in which it is signed, you need to make sure that you have a proper custodian arrangement with the party that is going to keep the note for you. So with those 2 comments on notaries and promissory notes, I'm going to turn it over to Simon, I believe. Or Fiona.
Hi. Hi. So the next point on security documents is all the difficulties that you may experience, particularly with being able to register and perfect security. Is this going to have an impact on my loan agreement? The reason we actually created this question quite this way is because we did have a number of clients saying to us, our borrower has come to us and said they're not going to be able to perfect their security, so they want to amend their security related undertakings and events of default. So our message to you would be, no, don't amend the underlying undertakings and events of default. If it's an existing deal where things just can't get finished, I would say you simply have to have a waiver of those conditions. If you're trying to get to financial close, then I think what you need to do is really carve out in the conditions precedent provisions very detailed conditions subsequent, so that it's very clear that all the things that due to lockdown you can't achieve by financial close are dealt with as conditions subsequent, so that they will happen by a named date. This obviously all requires your lenders to be happy with this, but we think this is the best solution rather than starting to remove any security related provisions such as further assurances, which any party or any lender particularly would need to ensure remains in their loan agreement. Your condition subsequent will require you to have a date certain by which things can be achieved. And one of the other problems we had, particularly when we were closing deals at the beginning of lockdown, was uncertainty. And no one really had any idea how long we were going to be in this scenario, what the impacts would be, particularly where registries may then reopen after a month or 2 months. and there would understandably be a backlog of other people trying to register their documents, and presumably people unable to get through work quickly enough. So what we would say is it might be an idea, where you don't know how quickly you're going to be able to deal with your condition subsequent, to tie your condition subsequent to a period of time following the reopening of the registry, for example, with security. And then legal opinions. Just a final point on this, and we've added this because it ties into both the e-signing protocols and also to the security related issues. It's worth bearing in mind that whoever is issuing your legal opinion, if you decide that you are going to e-sign, there may be a couple of tweaks that will need to be made to the assumptions in that opinion, because most legal opinions, particularly in the London market, have only very recently started providing reference to electronic signatures. Again, it shouldn't be anything too different to the assumptions that you have for virtual signings, but just be aware there may be slight changes in your opinion. The other thing that we wanted to put in here was particularly with respect to local council and perfection opinions. One of the big problems we've had reaching financial close and satisfying CPs is that the local council opinions often relate to the perfection of security. So as part of our condition subsequent process, we have had to require 2 local party legal opinions. One is the closing opinion, which talks to the due execution of those documents and the enforceability of those security documents, obviously with the carve out for the fact they've not been perfected. And then once we are able to resolve the various registration issues, once lockdown has lifted, there will be a further perfection opinion, which will wrap up all the uncertainties that were not able to be opined on for financial close. But this was a good way, if lenders are comfortable, of getting around the fact that you're not going to be able to get a clean legal opinion where security can't be registered.
Thanks, Fiona. We've got around 5 minutes left, so this disembodied voice is going to ask you a question that came across the Q&A. So the first one, which I'm publishing now, says, why can't you pre-sign pages under English law? That came in from an anonymous caller.
So you can, when we sign documents under English law, we do send them out with the various conditions, and particularly if you're signing a deed, we all need to be sure that everyone is signing exactly the same document. And that everyone knows what they're signing. And obviously you as a signatory have to send back confirmations that you agree to what you're signing. You can't really pre-sign if you're intending to change the terms of the document that you've sent back, saying that you've authorised all the terms and conditions of that agreement. And I'm aware that that's where we have a very big difference between New York law, where certainly parties can pre-sign signature pages while the underlying agreement is still being negotiated. But we simply can't do that under English law because the signature page has to relate to the final agreed document.
Great, thanks, Fee. And another one for you, another English law question for you. Can you do escrow under English law? I think Eric talked about it for New York signature pages. Can we do the same under English law?
Absolutely. Where we've sent out a document that has been agreed and everyone's ready to execute, there may obviously be various reasons why parties don't want documents released. So under English law, we as lawyers can certainly hold signature pages in escrow, and once everyone is happy, we can date the document and release it.
Great. Eric, one for you. So let me find you here. Eric, having worked on financing transactions under English law and New York law, which one would you choose from the point of view of ease of closing? I think we probably all know the answer here.
Yes, for the very reasons that Fiona has just outlined, I think that New York law provides some additional flexibility in terms of being able to sign documents in advance and have, if any changes, as Augusto pointed out in his comments, sometimes you have changes at the very last minute that occur to documents, and we found with the New York formatting of signature pages, it is far easier to just swap in the change without having to readjust any of the signature pages or having them re-signed. So New York law is definitely a bit more flexible than English law.
New York law wins. Okay, fine. We'll agree to disagree there, shall we, Eric? I've got a question for Augusto here. Is there anything positive that has come out of your experiences of closing deals during COVID-19, Augusto?
I think one has to be very creative and very flexible, and be prepared to to advise the client on what the risks might be of not being able to have a document ready or filed with the appropriate registry, and be able to allow the client to make the proper risk decision on whether they want to move forward or delay a transaction.
Eric, have you got a view? Have you got something positive to say coming out of the pandemic?
I think that there is, in the registration authorities that we have dealt with, I think there is more of a recognition that you have to move to an electronic platform. I think there is a renewed impetus for having these advances to make the registration process somewhat easier. So we have seen, as I say, the advice we get from some of the registries now is that, well, we have a new act, and so we have it easier this time around. We are seeing progress in that way, and so we're pleased to see that. Unfortunately, it takes a crisis, but there are some positive results with the registration process being moved to the next phase of its development, and we hope that continues.
Great. Fiona, what about you? Have you got a last word on something positive for us?
You're on mute.
I think the move towards e-signatures has certainly been quite positive. Particularly, we all have the problems on transactions where it can be hard to get hold of authorized signatories, and I think if people and if companies can put in place policies and procedures to enable e-signatures, it makes it much easier for the authorized signatories to be able to sign wherever they are in the world, be it on holiday or on a business trip on the other side of the world. So I think it should help in terms of organizing signings.
Great, thank you, Fiona. That brings us to the end of our 45 minutes. So the disembodied voice is just going to finish by giving you a quick advert for the upcoming talks that you can now see on your screen. If you're not already signed up, you can do that on our website under Trinity Talks, right at the top of the screen. So we look forward to talking to you all again next week. Thank you very much.